Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. So in this video, we are concluding the other three lamps of advocacy. Of course, we may become four also. Now, to quickly start with, we are discussing courage. What is courage? So please remember, with courage, you can stand in front of the bench. You can stand and argue the case with courage. So, and you can convince the judge with your courage. So, courage is the most important. So, before that, I want to give you the legal maxim, or generally we think success is not final. Please remember, failure is also not frail. So, success comes from failure only. But you must be courageous enough. That means, even though you produce large number of judgments, even though you argue on large number of, but the court did not agree, don't lose your hope or courage. Some judge will definitely, in the appeal stage, definitely accept. And you must stick to your point. Whatever is believed to be true, yes, you must be courageous enough to accept and to stand by that. This is what is called courage. So, advocate should possess the topic of courage. Once you accept a brief, then you should work hard to get success. You should know the legal position, and no doubt there may be some pressures from the outside. There may be pressures from the other side. There may be pressures from the legal side. So many, and you have to face them with courage. Because sometimes you may have to fight against the state. You have to fight against the politicians. You may be seeing the case of Mr. Shravan Kumar. Of course, he has become a politician from a judge. But you see, he is fighting with the political people. He is fighting with the judiciary. He will not care anybody. That is the spirit of courage, because he believes in certain legal point and he will stick by it. So that is courage. So sometimes he may have to fight against the collector. He may have to file a case against the collector for contempt. Don't be afraid. You must have the courage. And you must perform your duty. What for? To safeguard the interest of the client. This is more important. And sometimes in the early stage of your career as a junior advocates, don't have the so-called inferiority complex. Please remember, don't have any fear about the church. కొంతమంది చెప్తుంటారు మీకు జడ్జి గారు ఈ పిటిషన్ ఒప్పుకోడండి డామ్ డూమ్ అంటారు. ట్రై టు ఫైల్ ఇట్. సో ద జడ్జ్ ఆస్క్ యూ మస్ట్ బి ఏబుల్ టు టెల్. కొన్ని సందర్భాల్లో క్రాస్ ఎగ్జామినేషన్లో కూడా అడుగుతుంటారు, ఇన్ వాట్ వే దిస్ క్వశ్చన్ ఈజ్ లయబుల్ అంటే యూ మస్ట్ బి ఏబుల్ టు టెల్, యువర్ ఆనర్, to prove my case, this point is necessary. I will tell at the time of argument. Normally, court will agree. Then what you must have the courage. Like అమ్మో జడ్జి గారు అనుకుంటారనే పాయింట్ వదిలేస్తే your important arguments, important leading point will go away. You must have, and you must not hesitate also. Hesitate, so you must be bold enough, you must be courageous enough. So for this, the case law I have given the notes. Mrs. Geeta Hariharan and others versus Reserve Bank of India, 1992. This is a famous case, landmark judgment. So Madam Indira Jaising, she was the senior advocate in this case along with other advocates. So as far as the facts of the case goes too, so Geeta Hariharan and her husband, actually they have deposited certain amounts of money in the name of the children. Of course they have to part with, and Geeta Hariharan, actually she approached the bank and asked them to permit her to withdraw the FD amount. They did not do so. They said, you are not the natural guardian. Father is the natural guardian. According to Hindu Guardian and Minority and Guardianship Act 1956, father is the natural guardian. Father should come and say, yes, I do not have an objection. Or father has to give some endorsement. Otherwise, we are not going to release the FD amount. Then she approached Indira Jaising. She filed a case and she said, what is this? Is it not discriminatory? For a child, you think that only father is the natural guardian. Why not the mother? When the child is in the custody of the mother, why not the mother become the natural guardian? Yes, ultimately Supreme Court said, in these particular circumstances, mother also become natural guardian. So that is the courage with which Indira Jaising fought, and this has become a landmark judgment. You must have the courage. Then, eloquence. Eloquence is most important. Eloquence means not only fluency in language, not only bombastic language, not only the communicate with ability, but fluency of your body language is also important. With this, you must be able to draw the attention of the opposite party, attention of the opposite advocate, attention of the honorable judge also. When will it come? Through your eloquence only. So this is more important. So this is nothing but ability to communicate and having good body language also. Please remember. So the advocate should be eloquent, should be skillful, and also at the time he should not what words to be put at particular time. So that's why I always have been telling the language and tenor should be perfect. At the same time, he should not use the bombastic and flourish language which is judge has to refer to the dictionaries. It's not correct. You must be able to present the matter in an eloquent way, in a skillful way, so that it is appreciable by the judge also. That's why you must put the apt words at the appropriate time. And you must try to draw the attention of the judge also. Sometimes judges, they don't buy, this man is a boring man, he will be telling so many arguments. It's not like that. You should understand the psychology of the judge also. Suppose if the judge is in a hesitating mood, he wants to completely hear the arguments as early as possible, then you must try to finish them quickly. If he is having patience, yes, you can elaborately go with the arguments. So at the same time, please remember, even though you are eloquent, you should not misuse your communication skill. So please remember, you should not abuse your opponent party. Please remember, if you misuse your power of experience, it becomes a thunder upon yourself only. So anyway, it becomes professional misconduct also. So therefore, please remember, you must be skillful, the art of advocacy, the art of communication, pleasing manner, and appreciable to one and all. It must be appreciated by one and all. Otherwise, even though you are having the eloquence or fluency of speaking, there is no use. So please remember, you must be eloquent in your speeches. Then wit, yes, this is more important. Wit means being humorous. Wit means being humorous. So definitely humor is essential for everybody. So it comes from presence of mind. No doubt, in certain occasions, the court will be very busy. So many serious arguments will be conducted, and at the time, even though the judge is serious, if you crack a joke, of course, legal joke, not ordinary jokes, then the entire thing will be relaxed. Judge also feels happy. So no doubt, don't be serious always. So you must possess the qualities of humor and wit also. It lessens the hard work and relaxes the mind, and it creates actually lessens the mental strain also, and it creates harmonious relations between the bar and bench. So and it creates amicable atmosphere between the bar and bench also. And please remember, an ill-tempered angry man, maybe an advocate or maybe a civil person, is hated by the community, by the society. So likewise, an ill-tempered advocate is definitely not liked by his colleagues, staff of the court also, and the clients. So, and sometimes he may be liable, if you lose his tongue, definitely he is liable for punishment of the contempt of the court. So this is important. Just one or two examples I have given the class also. This is regarding Attorney General G. Ramaswamy, ex-Attorney General. So he was arguing a case very seriously at the time. Justice Kuldeep Singh, he said, "What Ramaswamy do? What advocate? You think that we are fools?" Then he said, "It's a very serious. The judge is very serious. Do you think that we are fools?" Then Ramaswamy said, "Your Honor, you have to put me in an embarrassing position. If I say ha, that means if I say yes, I am liable for contempt of the court. If I say no, I am liable for perjury." ఏమయ్యా మేమంతా ఎదలో అనుకుంటామంటే, సార్ అవునంటే నా మీద కంటెంప్ట్ వేస్తారు, కాదన్నా అనుకోండి అబద్ధం చెప్పామని కేసు పెడతారు, ఏం చేయమంటారు అనగానే the entire court fell into laughter. Second case before Justice Venkatachalaya by same Ramaswamy. He said, "Your Honor, my clients are very poor, they are not able to pay the electricity bill." It's the electricity bill case. Then Justice Venkatacharya Ramaswamy referred to page number 63 of the balance sheet of the tax balance sheet of those persons. Their company is running, or their annual turnover is 53 lakhs at the particular time, 1980s or 1980s. Then he said, Your Honor, if they were there, but after getting me appointed as an advocate, they became poor. Laughter. So this is what is called wit, the art of wit. Those who have come to the classes, they might have understood the importance of the wit also. With this, the 7 lamps of advocacy are completed. Now we are going to discuss the other lamp, that is tact. Justice K.V. Krishnaswamy Iyer, in his book Professional Conduct, he has attached the tact as 8th lamp of advocacy. So what is tact? Handling the situation in a very well manner. తప్పించుక తానవ్వక తగ్గి తిరుగువాడే ధన్యుడు సుమతి అని సుమతి. So you should not cause hurt the sentiments of others. At the same time, you should get the work done. Tact means understanding how to avoid the conflicting issues and how to get the goodwill also. So please remember, you must be tactful towards client, toward the opposite party, toward the opponent advocate and courts, because the profession goes in a smoother way if you are tactful. Right, is it not? So for that, he must work hard and he must tackle the issues naturally. He will be having knowledge at the same time. Unless you are tactful, it becomes very difficult for you to survive or struggle in the so-called profession. Right? So with this, I am concluding. Thank you very much.